Can we start? Good afternoon, everyone. I am CS Channakesava, Deputy Director, ICSI. Welcome you all for today's webinar on revised secretarial standards on meetings of the Board of Directors SS-1 and General Meetings SS-2. Dear participants, the ICSI has issued the secretarial standards SS-1 and SS-2 with an intent to provide a structured framework for conducting board meetings, committee meetings, and general meetings by ensuring compliance with legal and regulatory requirements. The aim to streamline corporate procedures and promote consistency in company secretarial practices by adhering to these standards, companies enhance their accountability and transparency, which in turn helps in building trust among the various stakeholders, including investors, regulators, and the public at large. Consequent to the revision in SS1 and SS2, this webinar is conducted as an attempt to guide our CS professionals towards brushing up their existing knowledge and make them privy to the recent amendments that have taken place in the regulatory and legislative arena. To deliberate further on the topic, we would like to welcome our esteemed speakers for the day, CS Nagendra D. Rao, Chairman of Secretarial Standards Board and former President, the ICSI. Welcome you, sir.
Thank you very much, Channakesava.
We also have with us CS Kalidas Ramaswamy, Member, Secretarial Standards Board and Practicing Company Secretary. Welcome you, sir.
Thank you. Good afternoon.
Good afternoon, sir. It's an honor to have you both among us for this webinar, sir. Before we proceed for this session, I would like to give a brief introduction about our speakers. CS Nagendra T. Rao is the designated partner and founder of the LLP, a fellow member of the ICSI. CS Nagendra D. Rao is a law graduate from University of Mumbai and has a bachelor's degree in commerce. He is a designated partner and founder of CS Nagendra D. Rao and Associates LLP, a firm of practicing company secretaries in Bengaluru. He was elected to the Central Council of the Institute of Company Secretaries of India for the term 2019-2022 and served as Vice President of the ICSI for the year 2020 before being elected as President for the year 2021. With over 20 years of experience in corporate sector, he specializes in corporate and securities laws, capital markets transactions, business planning, mergers and acquisitions, financial restructuring, strategic investment, funds planning, and arrangement. CS Nagendra D. Rao is presently Director in ICSI Institute of Social Auditors, a Section 8 company registered under the Companies Act 2013. He has been appointed as Non-Executive Independent Director of Prestonic Engineering Limited with effect from July 3, 2023. He is the Chairman of the Secretarial Standards Board of ICSI. He was also Director in Avava Environs Private Limited from October 29, 2011 to January 2020. He was the nominee director in ICSI Governance Research and Knowledge Foundation, ICSI IAP, and ICSI RVO from January 19, 2020 to January 19, 2022. CS Nagendra D. Rao was a member of the Central Taxes, Corporate Laws, and GST Committee of the Federation of Karnataka Chambers of Commerce and Industry, Corporate Affairs, and Taxation Committee of the Bangalore Chamber of Industry and Commerce. He has addressed several conferences, seminars, webinars, and workshops organized by the professional institutes, Indian Institute of Corporate Affairs, Institute of Directors, and trade bodies at national as well as international level. Prior to setting up his independent practice, CS Nagendra D. Rao has also worked in many multinational companies like Shobha Limited, Indonesian Foods Limited, and Wisman Homes Limited in various capacities in secretarial, legal, and treasury departments. In recognition for his outstanding service rendered in the field of education, CS Nagendra D. Rao was conferred the title Vidya Vikas by Dr. D.J. Shetty Educational Society, Karnataka. Thank you, sir, for being with us.
Thank you very much.
CS Ramaswamy Kalidas, having academic background, fellow member of the ICSI, MBA in Finance from Jadavpur University, Kolkata, BCom from St. Xavier's College, Kolkata. He is having professional experience, more than 4 decades of experience in industry after starting professional career in the year 1978. Worked in leading companies such as Ambuja Cements Limited, ACC Limited, and Company Secretary and Senior Vice President, Reliance Power Limited from October 2010 till June 2017. And also Company Secretary and Head of Compliance for ACC Limited from August 27 till December 19 upon superannuation. Now in practice, a partner of leading firm of practicing company secretaries. He is also having academic and professional achievements, visiting faculty in XLRI, Jamshedpur, a premier management institution, taking courses on corporate laws and governance, author of more than 100 articles on issues relating to corporate law, SEBI regulations, corporate governance, etc. Articles have been published in the Chartered Secretary, Taxman, SEBI, and corporate laws web portals such as lawyersclubindia.com, caclubindia.com. And also regular speaker in seminars and conferences organized across the country by professional bodies. Member, Secretarial Standards Board of the ICSA from 2020, and also a author of the following books: Law and Practice Relating to Company Meetings 2020, Law and Practice of Directors, Board Management, KMPs, etc., Commentary on the Law Relating to Directors and KMPs, an Integrated Approach published by the ICSI in 2023, Specialist Editor C.R. Datta on Company Law, Specialist Editor M.C. Bhandari's Company Law, Specialist Editor A. Ramaya on Company Law, 19th edition. Thank you, sir, for being with us.
Thank you.
I request Nagendra D. Rao, sir, to take forward the session.
Thank you very much, Chanakeshwa. Before I start, greetings to Kalidas sir and all the esteemed members who are present for this particular webinar. Before I start my presentation with regards to the revised Secretarial Standard 1, I would like to thank our Honorable President C.S. B. Narasimhan, as well as Vice President C.S. Dhananjay Shuklaji, as well as the Madam Banu, Rakesh, as well as Anamika, who were there, and Anamika presently who is there in the Secretarial Standard Board, as well as all the members of the Secretarial Standard Board right from the inception till now, who have helped to ensure that we have this book called as a Secretarial Standard Board. This book, according to me, is like a Mahabharata or a Bible or any other book you can see it, because it lays down the complete picture or a procedure with regards to the how a board meeting or a general meeting, how it has to be convened, and various questions which are there, which probably has not been put in forth in the act. And therefore you will find that members may have many of the anomalies or the queries or the questions from time to time, and therefore we will have to go to the repository of the Secretarial Standard. I would now request Chanakeshwa, if you can kindly put it on the screen, please, the presentation.
Yes.
Okay. By the time Chanakeshwa, okay. Can you go to the Secretarial Standard Board? As you know, that the Secretarial Standard Board on the either the meeting of the Board of Directors as well as the general meeting has got its importance via Section 118 subsection 10 of the Companies Act 2013, where these two standards have been made mandatory for the compliance. The Institute of Company Secretaries of India has issued many standards, whether it is on board's report, whether it is on dividend, whether many other secretarial standards are there, SS-1 to SS-10. However, you will find SS-1 and SS-2 has got its legal recognition by virtue of Section 118, subsection 10 of the Companies Act 2013. And you would find that most of the companies who were earlier reluctant to go through the Secretarial Standard, follow the Secretarial Standard by virtue of various, I may say that when we go through the Secretarial Standards, in the presentation, you would find there are many case laws, there are many adjudication order, where even the case laws, even as recent as you may take of Byju's, for example, you will find that in case of Byju's, you will find that a certain sect of the shareholders had convened extraordinary general meeting on February 23rd, and you will find the Byju's, their promoter company, had to go to the Karnataka High Court for the purpose of obtaining stay. You will find the Honorable High Court of Karnataka, though not staying the extraordinary general meeting, has stated that the whatever the decision, whatever the outcome of the extraordinary general meeting is, that particular outcome will be based on the decision of the Karnataka High Court. So therefore, you will find that important question again which will arise is because of the convening of the meeting, and therefore you will find the importance of the secretarial standard so far as the meeting is concerned. Similarly, you will find in case of Tatas versus Mistry, there have been a reference wherein it has been informed that whether proper convening of the meetings have taken place so far as the company is concerned. Can you go ahead, please?
Yes, sir.
Before I go to the actual presentation, a disclaimer that this is a presentation. It should not be construed to be a legal advice or an opinion, or this is only an individual presentation which is being made. Next. A brief introduction. The SS-1 and SS-2 formulated by the Secretarial Standard Board, approved by the Ministry of Corporate Affairs. Both the standards are having the mandatory imposition in terms of Section 118, subsection 10 of the Companies Act 2013. It was effective from 1st July 2015, and as of today, the said revised Secretarial Standard has been gone for two revision. One which is effective from 1st October 2017, and presently which is going to come from 1st April 2024. Before I go to the presentation, one general information which I would like to state, either as a former president of ICSI or as a chairman of SSB. We cannot often go to the ministry for small changes which takes place in the act. So therefore, and second thing is, kindly appreciate that whatever changes are taking place, the institute immediately puts it before the committee and immediately takes up with the ministry as well. However, it takes some time for the ministry to come up with the changes in the SSB, and therefore I would suggest that members should not feel that the act has undergone a change, whereas the SSB has not undergone change. Therefore, what will happen so far as whether we should follow the SSB or whether we should follow the act, or what is the thing which is going on. So therefore, rest assured, all these changes which are going to take place either not till now or in future, all in a consolidated basis are placed before the ministry, before the Secretary of the Ministry of Corporate Affairs, and then it is taken up and then it is approved. It takes time so far as the approval is concerned. For example, in 2019, what was given, it has come and approved as recent as 2023 end. So there 24 in fact. So therefore, you can expect certain delays which may take place not on account of the SSB, but on account of the approval which takes place, the process which is involved so far as approval is concerned. So friends, first thing which comes in the mind is which will prevail, whether the Companies Act, whether the Secretarial Standard, whether the Articles of Association. We have various types of companies: public company, private company, again private company with joint shareholder, with joint investors, wherein you have various entrenchment clauses, and you have government companies. So you will have a question which will prevail, whether it is Companies Act, whether it is Secretarial Standard, or whether it is Articles of Association of the company. Next. So first thing which we should know is that Secretarial Standard is more a set of principles. It is more a procedure. The Secretarial Standard does not prescribe something which is over and above the law. It is what is defined in the law, what is mentioned in the Act, in order to bring more clarity, in order to define certain things which has not been defined or which has not been mentioned, to bring in more clarity. you will find the same has been captured in the secretarial standard. So therefore, a question arises whether secretarial standard versus an act. So it is very clear that where the law is not clear or need explicit spirit of the law, the secretarial standards provide clarity on them. The secretarial standards only provide the clarity on the respective subject, but it does not mean that the secretarial standards are alternative to the original law. In other words, you will find that the standards, the secretarial standards, are only an addition, and it is not a substitution of a relevant provision of the law. And you will find that in case if there is any ambiguity between the standard as well as law, law will always prevail over the standards. Friends, there are many changes which takes place, and wherever there are subsequent changes in the act, a particular standard or a particular standard becomes inconsistent with that of the act, then the provision of the act shall prevail and the standard will not apply so far as that particular portion or that particular standard is concerned. Next. So first question arises, why? What is the need and importance of secretarial standards? Friends, law is subject to various interpretations. For that, you will find that secretarial standards aims to provide that correct interpretation in terms of meeting the objectives of law or the objects of law insofar as the procedure is concerned. The secretarial standard stipulates the maintenance of records, the registers for a specified time frame, for example, 3 years, thereby reducing the chances of disputes and litigations. Where the law is silent or ambiguous, the secretarial standards step in to fill up that gap and clarity and clarify those particular situations. Secretarial standards mandate appropriate disclosures resulting in transparency and improved governance. Secretarial standards are thus compliance and governance standards that provide greater assurance to all the stakeholders. Next. What is the essence of secretarial standards? The most important point why we should have secretarial standard, and whether it is applicable only for a private limited company, public limited company, only for a listed company, all those questions we will take a little bit later. The basic essence is better corporate governance. When we talk about better corporate governance, we talk about disclosures, we talk about transparency, we talk about not only the compliance of law, but also the spirit of the law. Mitigation of litigations. Various litigations comes in, and as a former president and former presiding officer of the disciplinary board, many cases comes in terms of the following of either SS-1, SS-2. So in order to ensure that our fraternity, our company secretaries, they have to ensure that they maintain, they keep, they follow all the SS-1 and SS-2 so that they do not come before the disciplinary proceeding in regards to the violation of the various provisions under the SS-1 as well as SS-2 as of now. Standardized process. Many corporates, many company secretaries follow diverse practices so far as the preparation is concerned, notice is concerned, minutes is concerned. So in order to ensure that there is a standardized process, you will find the SS-1 and SS-2 has come into being. Improved compliance. Friends, as known to you that the cost of compliance is too heavy. And in that sense, you will find in case if there is a simple non-violation, as of today, you will find all of you are aware of, by virtue of a circular being issued, all the ROC's office, none of the forms are being processed at the ROC's office, and all the works of the ROC's office, but as of now, are being done at Manesar, at the Indian Institute of Corporate Affairs, as well as at the MCA at the Manesar. So you will find over there that ROC will be now more so will be looking into various adjudication matters, various litigation matters, and by virtue of which we have to ensure that there are compliance in place. Otherwise, you will find that day in, day out, you will find various show cause notices in terms of even tribal matters in certain part of SS-1 as well as SS-2 will hit us. Stakeholders' confidence. Stakeholders' confidence, it can be any stakeholders. The moment you are complying with the secretarial standard SS-1 or SS-2, you will find there is a set process in, a board process system set in, and therefore you will find the confidence among the stakeholders, among the directors would increase. And last but not the least, the transparent practices. The transparent practices in terms of the disclosure, in terms of the various guidance being issued. For that particular purpose, you will find the transparent practice which is being followed by the company secretary in terms of the issuing of notices, issuing the agenda items, agenda particulars, notes to the agendas, as well as the process which is being followed so far as the meeting is concerned. Next. Friends, as I have already told, that secretarial standard is nothing which is above the law. The secretarial standard has been devised, which is corresponding to the various sections under the Companies Act of 2013. So the meetings, say for example, section 173 to section 178 lays down the various formalities in terms of what a board has to do, how a meeting needs to be convened, what are the laws so far as meeting is concerned, so far as the quorum is concerned, so far as the attendance is concerned, and whatnot. Similarly, you will find section 118 of subsection 10 of the Companies Act mandates so far as the SS-1, SS-2 is concerned. Section 175, which deals with the circular resolution which can be passed, or those resolutions which has to need to be mandatorily passed at the board meeting. Similarly, the disclosures. So you will find section 135 subsection 5F of the Companies Act 2013 speaks about a disclosure where in the board's report you will be specifying whether you have complied with the secretarial standard SS-1 as well as SS-2 is concerned. So this secretarial standard has been devised in such a way where you will find that it has been put into 9 paragraphs, commencing from the convening of the meeting, where we speak about that how a meeting can be convened or who can convene a meeting, whether a director can convene a meeting or whether a chairman only can convene a meeting, exactly who can convene a meeting, or whether a meeting can be convened by virtue of requisition. If that be the situation, what kind of requisition, whether it can be an oral requisition, whether it can be a written requisition, or whether a director calls a meeting, whether chairman says he does not want to convene a meeting. Similarly, frequency of meeting. Similarly, quorum. What are the minimum number of members which are required so far as the quorum is concerned? Whether quorum is required to be present throughout the meeting, or only at the beginning of the meeting, or at the end of the meeting, that is with regards to the quorum. So we will go one by one with regards to the secretarial standards. Let us go to the first, that is the convening of the meeting. Friends, many question arises with regards to the convening of the meeting. Next, Chinakeshu. First, convening of the meeting. Before convening of the meeting, first question which arises is to whom this secretarial standard is applicable. Whether this is applicable for a listed company, whether applicable for a private company, whether applicable for a government company, whether applicable for Section 8 company, whether is it applicable for companies which are formed under this special act. So Secretarial Standard 1 very clearly talks about to whom this particular standard is applicable. So it is applicable to all the companies except one person company, because you will find there is only one director on the board and he himself is going to take the decision. You will find secretarial standard does not apply to such company. Similarly, company registered under Section 8 of the Companies Act 2013, for them, to the extent applicable, you will find that secretarial standard is not applicable to Section 8 company. In other words, you will find it is applicable for a private limited company, applicable for a listed company, applicable for the government company, applicable also so far as a company which has been formed under the special act, except to the extent in case there is an express provision with regards to the meetings, with regards to the quorum, with regards to the minutes. to that extent, the special provision or those special act will override the secretarial standard. Next. Authority, that is the first para of the secretarial standard vis-a-vis with that of the section 173 of the Companies Act 2013, start with the authority of convening a meeting. So first question which arises is that whether I need to, who can convene the meeting, whether it is any director, whether it is the chairman of the company, whether it is the chairman of the board, whether it is the any of the director of the company. So who can, or whether company secretary himself can convene the meeting. So who can convene the meeting? That may be the first question. Who may summon the meeting? That may be the first question which would arise. The second question which would arise is with regards to so if a director wants to convene a meeting by virtue of a requisition, an individual director he wants to convene by virtue of a requisition, can he convene a meeting? Whether that requisition can be oral, that requisition can be in writing. The third question can come out is whether a director has summoned a meeting. However, the chairman does not want to convene the meeting. So what would be the option out so far as the company secretary is concerned? And whether still a meeting could be convened? If so, what would be the provisions for the same? So the secretarial standards talk about the authority for convening the meeting. So who can convene the meeting? Any director may summon a meeting. In other words, a director may include any director, including an independent director, including a nominee director, including an alternate director, including the original director, including the director as defined under the Companies Act 2013. In other words, chairman need not necessarily summon the meeting. A director, an individual director can summon the meeting so far as the board is concerned. So when he summons the meeting, what is the responsibility of the company secretary? So the responsibility of the company secretary is that in case a company secretary, or there may be a possibility that there may not be a company secretary, for example, in a private limited company, a small company, say for example, in such a situation, the company secretary or any person authorized by the board on the requisition, a requisition can be oral, a requisition can be in writing. However, in order to avoid any ambiguity, you will find that we always recommend to inform to the director that please send a written requisition so that there is no issues, there are no problems so far as the convening of the meeting. It shall be convened in consultation with the chairman, oblique the managing director, oblique the whole-time director, unless otherwise stated in the articles of association. So therefore, we need to also check what are the provisions with regards to the convening of the meeting so far as companies who are having certain entrenchment clauses, certain specific clauses so far as the conduct of the meeting. So in that particular cases, we need to check the articles. If the articles talks about certain additional formality, we need to comply so far as those provisions are concerned. Meeting has been convened. After convening the meeting, you will find there are two situations arises. The chairman wants to adjourn the meeting. Can he adjourn the meeting? Answer is A, in case where all the or majority of the directors, two situations. A, he can adjourn the meeting where he gets all the directors or the majority of the directors, you will find they all the directors of the meeting who consents to his adjourning the meeting. B, in case if the majority of the directors do not wish to adjourn the meeting, in that particular cases, you will find that the meeting cannot be adjourned. So therefore, a chairman may adjourn the meeting for any reason at any stage. In most of the government companies, we see, most of the government companies, that there is a call which comes from normally the chief secretary or the principal secretary or the joint secretary may be heading the meeting, the chairman of the board. And you will find suddenly there is a call from top bosses, PM, CM's office or X or Y, and he need to rush off to that particular cases. So in those particular cases, you will find a typical situation where the majority of directors, in case if the object, in that case, the chairman cannot adjourn the meeting so far as the board meeting is concerned. Next situation is what will happen to that particular adjourned meeting in case if all the directors or all the members who have agreed to adjourn the meeting. In that case, the meeting stands adjourned to the next week, same day, same time, same place. In case if the same if the adjourned meeting happens to be on a public holiday, in that case the adjourned meeting cannot be held at that particular public holiday. We'll see a little bit later on the particular provision. Then we come to date, time, place and mode and serial number of the meeting. Meeting can be convened at any time on any day. In other words, an original meeting can be convened at any time, but an adjourned meeting cannot be convened on any national holiday. Friends, all of you are aware, there are 3 days which are constituted to be a national holiday. First is our Independence Day, second is the Republic Day, and third is the Gandhi Jayanti, October 2nd is the national holiday, so far as public national holiday, what we call as, and therefore the adjourned meeting we cannot hold on these particular days. However, the original board meeting can be convened at any time on any day, including a national holiday. So therefore, there is no restriction so far as the original meeting is concerned, but adjourned meeting, there is a restrictions. Similarly, you will find it is the meeting vis-a-vis with that of SS-2, where we talk about the general meeting, where our senior colleague CS Kalidas sir would be speaking about. Here we have no restriction so far as board meeting is concerned on the time factor. So you will find that convening preferably during the working hours. So, but we know that today the meeting goes on around the clock, because you will find you have various, especially the independent directors, you or many other directors you will find spread across all across the world. So therefore, you cannot precisely say that you can conclude during that particular working hours or not. But at least the start of the meeting, you should ensure that the meeting starts during this working hours of the particular company. We need to also check the articles of association so far as the meeting is concerned. Is there any restriction? Is there any requirement so far as specific or a special requirement so far as the convening about the date, time, place and mode of the meeting is concerned? Every meeting to be serially numbered. Friends, when we passed out during especially the old timers, there was nothing called as a meeting to be serially numbered. So you will find that the meeting when we used to do the minutes at especially the senior members would appreciate that we just used to mention what type of meeting, notice of the board meeting is hereby given and blah blah. But here now we have to speak about which meeting date, that is the 10th meeting or the 11th meeting or the 15th meeting or the 115th meeting, serially numbered. Now this serially numbered, it is not consecutively numbered, it is serially numbered. So you can, depending upon your choice, maybe in that calendar year, maybe in that financial year, you can narrate as 1 2023/24 or 12th 23/24 as the case may be, because it talks about the serially numbered. It does not talk about the consecutively numbered as against that of the minutes. So therefore, you have to mention very specifically the serial number, the notice at the number, which notice number you are sending. That is the 10th meeting or the 12th meeting or the 15th meeting as the case may be. Similarly, meeting can be convened at any place. So there is no restriction so far as the convening of the board meeting is concerned, so far as the jurisdiction is concerned. You can convene at any point of time, anywhere, so far as the meeting goes. Unlike where you talk about where your registered office in the same city, town, place, village, so far as the general meeting is concerned. So meeting can be convened at any place. So far as the video conferencing as well as audio video meeting is concerned, again you will find they can be allowed. Again here many questions which comes in, whether so far as VC or OAVM meeting is concerned, should I take one-time approval before the beginning of the financial year, or maybe every meeting should I take so far as the directors asking for that they require any video conference or an audio video meeting is concerned, or I have opted for an VC or an OAVM, but I want to be physically present at the meeting, or there may be certain items which earlier you will find prior to the recent circular which is issued. Now all the matters can be taken up before the video conferencing as well as the audio video conferencing facility. So in that case, whether VC of the audio video meeting can be allowed. So today you will find the board of directors or the directors or in your notice, whenever you are sending a notice to the directors or to the board of directors, you can specify very well that those directors who wish to take the VC or the OAVM meeting facility, they can opt so far as the meeting facility is concerned. Or you can take a declaration in advance in writing whether which directors want to attend the meeting so far as the video conferencing or other audio video mode is concerned. Next. So notice shall be given to all the given in writing to all the directors of the company. So to all the directors, so you will find you need to give notice of that particular meeting to alternate directors, to also an original director for information, to nominate directors, to all the directors, independent directors, to all the directors by whatever name called, you need to give them, which forms under the Companies Act 2013. Question arises sometimes that you want to co-opt an additional director in the meeting, whether you need to give notice to that particular additional director as well. So we feel that yes, you should give notice to the additional director, and you should, when you are drafting the agenda, when we speak about the agenda item, because you are initially inviting him to attend the meeting, the first item which should be taken, because he may not be having the, you will have to give him also the agenda papers, because notice as well as the agenda item needs to be given. There may be a question which may be asked by the rest of the directors of the company about his presence, and therefore the first item which should be taken into account is appointment or co-option of that particular additional director into the meeting, so that that particular additional director can validly participate in that particular meeting. So notice shall be given to the directors in writing to all the directors of the company. Notice shall be issued by the company secretary or director or any other person authorized by the board. So it is the responsibility of the company secretaries, in case if a company is having, or the director in terms of the secretarial standard, as well as you will find there will be a specific provision normally which is captured in the articles of association of the company. Notice shall be given even if the meeting is on predetermined dates intervals. Normally, we always find, especially in big listed companies and also in other companies, most of the companies, that at the time of conclusion of the meeting, they have already a set date which is being mandated by the directors, because especially in listed companies, you will find directors, many of the independent directors will be directors on many other companies on the board, and therefore they would like to know when the board meeting will be convened, so that they can appropriately chalk out their plan so far as attending of the other meetings are concerned. So therefore you will find, even though it is on a predetermined date, you will have to inform to the directors about the particular date of the meeting. Many of the good listed companies, you will find only at the beginning of the year itself, they will come out with a the date of the meeting, so far as all the 4 quarters are concerned, so far as the meeting is concerned. When, for example, all the 4 quarterly audited accounts or an unaudited accounts are being approved, so based on that, you will find the dates are only already concluded or already been done at the initial, at the beginning of the year itself, so that the directors can plan well. Notice to be given at least 7 days prior, unless the articles of association provides for a longer term. So you will find the notice to be given 7 days prior, unless the article provide. So you will find certain articles of association may have a restriction clause, may have an entrenchment clause to start to talk about that a specific timeline. It may not necessarily be 7 days. It may be say 10 days or a 12 days or a 15 days. Or there may be certain items where you will find that for certain specific items, notice also needs to be given to Mr. A, Mr. B, Mr. C, depending upon what articles of association you would have entered into, especially the entrenchment articles, what would have. And normally you will find that those particular clauses would also be captured in the articles of association of the company. Proof of sending notice and its delivery shall be maintained by the company. So you will find that there are sometimes many litigations takes place. Or take a simple example, we are filing DIR 12 so far as removal of directors are concerned. So in those particular cases, it is not a straight through process. It is by virtue of a approval process. So in those particular cases, or say, for example, vacation of office of a director on account of not attending for consecutive board meetings. So even in those particular cases, you will find that you need to provide a proof of sending a notice, because the registrar of companies will ask you whether you have sent a proper notice to him with regards to the meeting convening with regards to his removal as a director of a company, or a director by not attending the meeting for the consecutive absence in the board meeting. Similarly, the delivery, how the notice should be delivered, whether by speed post, registered post, by courier, by hand delivery, by virtue of an email. So those provisions which we will be speaking a little bit later on. Notice shall inform the directors about the option available to participate through electronic mode. When a notice is given to the alternate directors, we have already discussed, we also need to give to the original directors. Though original directors has got a right to receive the notice, but he may not have a right to vote at that particular transaction, because he has already given a instruction, or he has appointed already an alternate director so far as the meeting is concerned. Next. The meeting of the board shall be called by giving not less than 7 days notice to every director, though provided that a meeting may be called by shorter notice. This is here again, whenever we are calling a meeting by a shorter notice, we have to ensure that we have to be expressly specific, not only in the notice, but also in the minutes, to specify that this particular meeting, the 10th meeting or the 11th meeting or the 12th meeting, it is being convened by virtue of a shorter notice, and it needs to be captured in the notice as well as in the minutes of the particular board meeting. And this shorter consent meeting is being considered for certain urgent business, which they cannot wait till the ensuing board meeting or the future board meeting, and therefore they are conducting this particular board meeting, for which you will find at least one independent director shall be present at the meeting. There may be a possibility that an independent director or that one independent director may not be present in that particular meeting. So in that case, you will find whatever decision has been taken by the board of directors, it shall be subject to the ratification by at least one independent director. So therefore, you will find that when the board minutes are being circulated to those all the directors of the company, whether they attend the meeting or they do not attend the meeting, it needs to be ratified so far as a shorter consent is concerned. In case of the absence of the independent director or not participating in that particular shorter consent meeting, you will find that one independent director, at least one independent director, have to ratify the decision which has been taken at the board meeting. The participation of a directors in the board may be either in person or through video conferencing or other audio visual means. So you will find that the directors can be either in person, physically present in the meeting, or in case if they have been offered and they had requested for the video conferencing facility, then they can attend that particular meeting so far as through the audio video mode. You will find that there is a case law. There are many case laws. Recently, in fact, in our office, we had prepared a chart or a table so far as so many violations are concerned, and especially those companies who have gone ahead and voluntarily gone for an adjudication so far as various violations are concerned in case of an SS-1 or SS-2 is concerned. Similarly, you will find one such case wherein the company Lifestar Pharma Private Limited has violated the provision of under Section 173 of the Companies Act with regards to the notice of convening the board meeting, where you will find the meeting which was, the notice which was sent was not the timeline of 7 days, which is not less than 7 days meeting, that was not being followed by the company, and you will find the ROC of the National Capital Territory of Delhi and Haryana has imposed a penalty of 2,25,000 on each of the directors. And there are many such cases, many such precedents are there. Nowadays, you will find the regulatory authorities as well as especially the ROC ones are coming very hard so far as ensuring that we are maintaining, all the company secretaries as well as the companies are in compliance with the SS-1 as well as SS-2 is concerned. Next. Meeting of the board, frequency of the meeting, that is para 2. Now the question arises, we spoke about the notice of the board meeting. Whether the same notice applies also to the committees which are being constituted. For example, there are various committees under the Companies Act which are constituted. For example, like you will find audit committee, you will find the CSR committee, you will find the nomination and remuneration committee. Similarly, you will find the stakeholders relationship committee, which has been constituted under the Companies Act under Section 178 of the Companies Act, and as well as CSR under Section 135 of the Companies Act. You will find even mutus mutandis, you will find the same will also be applicable so far as the secretarial standard is concerned. The notice also needs to be sent so far as those to the members of those particular committee is concerned. Second is the meeting of the board. The company shall hold at least 4 meetings of the board in each calendar year. Friends, we are talking about the calendar year and we are not talking about the financial year. We are talking about the calendar year with a maximum interval of 120 days between any 2 consecutive meetings. So therefore, you will normally find that questions which will arise that what will happen whether independent directors meeting, whether it is financial year, whether it is calendar year, whether we should convene them also in the calendar year or whether it is the financial year. So you will find the independent directors meeting is not being under the Companies Act of 2000, the constitution of a separate independent directors meeting is not been contemplated, and therefore you will find which comes under the SEBI regulation, under the listing regulations. So therefore, you will find that you may hold in the particular financial year so far as that meeting is concerned. However, we always recommend to ensure that you kindly comply with the provision of SS-1 even for the independent directors and all other meetings are concerned. Various committees are constituted so far as even in the case of a listed company. For example, risk management committee, So far as investment committee, borrowing committee, many committees are constituted. So we always ensure, or we always try to inform our clients as well as to all the companies that also kindly comply with the SS requirement. So far as, even though it may be an optional, because SS-1 is in terms of the mandated under the Companies Act 2013. And when we talk about an act under the SS Act, the act is defined under the Companies Act or any other previous Companies Act in force. And therefore, you will find that for the investment committee, borrowing committee, though may not be applicable, but we will always state that it is a recommendatory provision, but all the companies needs to comply the same. So meeting shall hold at least 4 meetings of the board in each calendar year with a maximum interval of 120 days between any 2 consecutive meetings. Meeting of the committees. Committees shall meet as often as necessary, subject to the minimum number and frequency prescribed by any law or any authority or as stipulated by the board. So you will find there are mandatory committees like audit committee, which is there in the Companies Act under the section 177 of the Companies Act. Similarly, under the regulation 18 of the SEBI LODR. Similarly, for the nomination remuneration under section 178 vis-a-vis with that of the regulation 19 of the SEBI listing regulation. Similarly, the stakeholders relationship committee under section 178 and regulation 20 of the SEBI LODR very specifically speaks about. So therefore, you need to comply mandatorily so far as the audit nomination stakeholder is concerned. Under the Companies Act, even when under section 135 of the Companies Act is applicable to certain companies within the to whom section 135 subsection 1 applies, even for them, you will find that you need to comply the secretarial standard to the extent applicable to such corporate social responsibility. For example, 1 meeting only needs to be convened so far as CSR is concerned. So to that extent of notice, agenda items and all other requirement is concerned, that needs to be followed so far as the CSR is concerned. Similarly, you will find that the Companies Act 2013 does not speak about the risk management committee in terms of constitution. So even in that case, you will find, though the SEBI LODR requires it, we always advise our client to ensure that kindly comply with the SS requirement, though it may not be mandatorily applicable. Meeting of the independent directors, where a company is required to appoint an independent directors under an act, such independent director shall hold at least 1 meeting in a financial year without attendance of non-independent directors and members of the management. Though we may take the help of company secretary in terms of drawing of the agenda items, in terms of the notice, but you will find that over here that you may hold the independent directors meeting in a financial year. Though we also inform that you also better to comply, though it is optional, to comply so that there is a uniformity which is so far as the independent director also vis-a-vis with that of the other meeting. Next. Every company shall hold the first meeting of the board of directors within 30 days of the date of incorporation, and subsequent meeting 4 meetings of its board of directors every year with not more than 120 days between 2 consecutive meetings of the board. I think this is there is a clarity so far as the provision is concerned. Next, where a company is required to, I think this we have already hold. Okay, so we'll go to the case law, where you will find that Dana India Private Limited company failed to conduct 4 board meetings in a year in such manner not more than 120 days intervened between 2 consecutive meetings. Adjudicating authority imposed a penalty of 25,000 on each of the directors of the company. So you will find day in and day out, you will find that even though we have, in case if we fail to convene the meeting as per the law or as per the secretarial standards, you will find that you will unnecessarily face the consequence of the violations. Next. Quorum. The first question which comes is whether the quorum should be there throughout the meeting, or only at the commencement of the meeting, or at the end of the meeting. You will find the Act does not specifically specify with regards to the presence of the directors, whether throughout the meeting or not. But the Secretarial Standard clarify that the quorum shall be present throughout the meeting, and it should be not only at the commencement of the meeting, but also throughout while transacting the business of the meeting. There may be a possibility that while transacting the meeting, there may be directors who may wish to leave the meeting. So thus those particular cases, it is the responsibility of the company secretary to ensure that when he leaves, when he joins, all those details he captures appropriately, so that he can inform to the chairman, as well as in the minutes is appropriately captured. A director shall neither be reckoned for quorum nor shall be entitled to participate in respect of any item in which he is interested. So a director who is interested, you will find he will not be taken into account so far as the quorum requirement is concerned. Directors participating through electronic meeting in a meeting shall be counted for the purpose of quorum, because the physical presence, the word physical can be interpreted in terms of the word in the meeting as well as through the VC, because he has been given the facility, or he has sought the facility and he has attended the meeting. So therefore he is physically present through VC. Meeting of the board. The quorum of a meeting of the board shall be 1/3 of the total strength of the board, or 2 directors, whichever is higher. Meeting of the committee, unless otherwise stipulated in the Act or article or under any other law, the quorum for the meeting of any committee shall be specified the board. If no such quorum is specified, the presence of all the members of such committee is necessary to form the quorum. So therefore, whenever we are drafting so far as the committee meetings are concerned, whether audit, stakeholders, other, we should be careful, because even if we do not specify with regards to the quorum, then all the members' presence would be required so far the quorum is concerned. Next. The quorum for a meeting of the board of directors shall be 1/3 or 1/3 of its total strength, or 2 directors, whichever is higher, and the participation of directors by video conferencing shall also be counted for the purpose of quorum, because he is personally present through VC. So directors present through VC or OM counted for the purpose of quorum. Alternate directors to be treated as interested, and he is not entitled to vote if he himself is interested. If the original director is interested, and if the alternate director is not, then he can be counted for quorum, as well as then he can also vote so far as the alternate director is concerned. But if the alternate director is interested, he cannot be counted so far as the quorum, as well as so far as the voting is concerned. Disclosure of interest at the first board meeting which he participates, or in the first board meeting of every financial year held after that particular change. So you will find normally either he may join a new as a director of a company, or he may get himself he may be, or his tenure would have come to an end as an independent director for 10 years for the term of 2 terms, or he may himself resign from some other director from the board of directors of the company. In such cases, you will find that he needs to inform the change, whether it is addition or whether it is or his resignation from such particular company to the through by virtue of filing the MBP1 and other disclosure, so far as the disclosure of interest is concerned. In case of related party transaction, the interested party can neither be present at the meeting nor he can vote for such particular transaction. There may be a possibility that during a particular meeting, all the directors or most of the directors would be interested, especially all the directors. Then that particular decision that can be taken by the shareholders of the particular company so far as the related party transactions are concerned. Quorum requirement for the committee as specified by Act or Articles of Association or the board. If it is not specified, all the members of the board shall be there in those particular committees. Next. Attendance at the meeting, as well as the attendance register. So attendance register, there are questions which may come up to say why attendance register is required when minutes is already there, where in the minutes we are capturing saying that the directors are present or present through audio video mode, or in case of certain transaction where he is present or he is absent. In those particular cases, attendance register is an important document or a register so far as the company is concerned, and hence attendance register is also required. Not only the attendance register, but also for the board, but also attendance register for the committees. Few companies we have seen that the attendance register, how they keep is the same attendance register is hold for the board, same is for the committee, and same is used for all other purposes. We would request that it should be separate. The board attendance should be separate, because you have to also consecutively number those particular attendance register. Similarly, that of the committee attendance register. So the attendance register has to be serially numbered and date of the meeting, name of the committee, whether audit, stakeholders, and all. Place of the meeting. So even in case you will find in an audio video mode, when a notice is being sent, we will be defining as to what is the deemed place of the meeting so far as the meeting is concerned. Name and signatures of the directors, company secretaries, and as well as the invitee. So there may be many invitees. It may be a secretarial auditor, it may be a statutory auditor, or it may be any other invitees which the company would have invited depending upon a transaction to transaction. In such case, even those invitees have to sign as an invitee. Attendance register shall be deemed to have been signed by directors participating through electronic mode. So question arises as to how they will sign in the attendance register. So you will find that in those particular cases, in the attendance register, the company secretary can mention their attendance through the audio VC as well as audio video mode, and he can authenticate that so far as the attendance register is concerned. The attendance register shall be maintained at the registered office of the company or such other place as may be approved by the board. It shall be open for inspection, and there are situations that if a director who ceases to be a director, even in that particular cases, he is having a right to inspect that attendance register during the period in which he was a director. The attendance register shall be preserved for a period at least 8 financial years from the date of last entry made therein. The attendance register shall be in the custody of the company secretary. Next. Leave of absence. Leave of absence question comes whether leave of absence has to be requested, or in most of the cases we find that we inform to the board, okay, these directors are not present, so let us grant a leave of absence. However, you will find that leave of absence shall be granted to a director only when a request has been received for such leave, which has been communicated to the company secretary or to the chairman or to the person authorized by the board to issue notice of the meeting. In order to ensure that there is no ambiguity in future, it is always recommended to get the leave of absence in writing. Next. Violation of in declarations by incoming independent directors, which was not noted in the minutes of the meeting. You will find the company was held liable for the violation, and you will find the penalty was imposed on the company 50,000 rupees. Penalty was imposed on the company as well as the officer of in default. Next. Chairman. Chairman plays a very important role so far as the meeting is concerned. So question arises as to who is going to chair the meeting, whether it is the chairman of the company, whether it is the chairman of the board, who is going to chair the particular meeting so far as the company is concerned. So the chairman of the company, in case if there is a chairman of the company, then he shall chair the, he shall be the chairman of the board, and he may chair that particular meeting. there may be a situation that the articles of association of the company may also state very specifically as to who is the chairman of the meeting. Or in other cases, the director may elect one of them to be the chairman of the board. I was going through WhatsApp yesterday, and there was a question which was put in there, that all the directors are present, but none of them want to be the chairman of the meeting. So aptly replied by one of our seasoned professionals that you have to have a chairman of the meeting on the board of directors. Without the chairman, you cannot convene you cannot conduct the proceedings of the meeting. In other words, without the chairman, further proceeding cannot take place so far as the meeting is concerned. In that case, what will happen? Whether it will be adjourned or whether the meeting stands cancelled. That question also arises because there is no chairman so far as the meeting is concerned. The chairman of the board shall conduct the meeting of the board. In other cases, the directors present at the meeting shall elect one amongst themselves to conduct the meeting unless otherwise provided in the articles of association. So meetings of the committee, a member of the committee appointed by the board or elected by the committee as a chairman of the committee. Normally, when we draft the resolution, most of the professionals, when we have seen draft the resolution, they very specifically capture as to who is the chairman and who are the various members of the committee. And especially for the listed company, since we need to file the corporate governance report every quarter, you will find normally the resolutions is automatically captured as to who is the chairman and who are the members of that particular committee. In accordance with the Act or any other law of the article shall conduct the meeting. In other cases, members present at the meeting shall elect one of themselves to chair and conduct the meetings. So it may happen in a committee meeting also. There may be a possibility that the chairman may not be present at that particular occasion. So even in such cases, the members who are present in those committee meetings may, in that case, may elect themselves as the chairman and proceed with the meeting. Managing director CEO cannot be appointed as chairman unless the articles provide otherwise or company does not carry multiple bills. This is under section 203, subsection 1 of the Companies Act. Please move forward. Passing of resolution by circular. Question comes as to when a resolution by circulation can be passed. Whether all the items can be passed to circular resolution, or is there any bar so far as passing of the circular resolution is concerned, or who has got the authority to pass the circular resolution? Should the notes so far as the proposal should be mentioned in the circular resolution? Whether if there are 4 agenda items so far as the circular resolution is concerned, whether one signature for all those 4 agenda items are sufficient or 4 separate signatures for each individual agenda items are required. So many questions which comes in so far as even passing of resolution by circulation is concerned. So who is having the authority? So first is that chairman, managing director and non-interested director has the authority so far as passing of the resolution of circular resolution is concerned. However, in case if not less than 1/3 of the directors require a circular resolution, then it cannot be passed. You need to hold it at a board meeting. So in other words, the 1/3 of a directors make a representation or sends in writing stating that a particular circular resolution in that meeting, stating that instead of a circular resolution, that agenda item needs to be threadbare discussed, deliberated. Then in that case, the circular resolution cannot be put before the board of directors of the company. The circular resolution should come along with the resolution, which is the draft resolution, which is required to be passed. It shall contain the details of the proposals, what are the various material facts, the necessity of the passing so far as the circular resolution is concerned. The next question which arises is when that circular resolution is effective or when it is said to have been passed. So it is deemed to have been passed on the last date of assent by the directors. So normally you will find that in a circular resolution, when it is sent, you will be mentioning as to when when all the director has to come back and give their assent or dissent so far as the circular resolution is concerned. Normally you will find that you will very clearly specify that the assent or dissent has to be given within 7 days of the draft circular resolution which has been sent. The reason being, if you can 7-day circular resolution is being passed for an urgent agenda item which needs to be passed, and you need not have to wait till the board meeting date, and hence you will find, because if you are going to give more days, then very well you can issue the notice of 7 days so far as convening of the board meeting is concerned. So you will find that the deemed date of passing is the last date when the assent has come, or the date on which the assent from more than 2/3 of the directors have been received, whichever is earlier. Say, for example, a circular resolution has been sent on 1st and the last date is set to, say, for example, within 7th, the circular resolution needs to be passed. Say, for example, out of, 7 directors, 2 of them have sent on the 2nd day and another 2 has sent on the 3rd day. So since the majority of the director happened to be on the 4th, that is on the 3rd of the on that month, then the resolution have been said to have been passed on that particular day, assuming depending upon the number of directors who are present at that meeting. Assuming 5 directors, 3 of them, of which 2 has given on, say, for example, 1st itself, and the 3rd director is given on the 3rd of, say, for example, of April, then 3rd of April is the last date. Out of 5 directors, majority happens to be 3. So you will find the assent has been given on that particular day on which it has been received. Or supposing on the 1st itself, all the directors have given their assent and the last date of receiving was 7th. So on the 1st itself, the circular resolution is said to have been passed. Next. There are situations where there is no assent or dissent which has been sent. Even in that particular cases, you will find it will be deemed to be it is deemed to have been abstained, and that particular abstain needs to be properly recorded in the minutes. When you are in the minutes, when you are taking note of the circular resolution, in that particular point, you will have to very specifically capture about the assent, dissent, as well as who have abstained so far as the meeting is concerned. All items of business may be considered for the purpose except certain items which we will see a little bit later on. Resolution passed by the circulation shall be noted at a subsequent meeting of the board. So there has to be, normally we will find in most of the board minutes, it is captured, and in case if there is no circular resolution passed, there will be a heading that no circular resolution which has been passed from last meeting to this meeting. Dissent or abstention shall be recorded in the minutes. Proof of sending and delivery of draft resolution shall be maintained for 3 years. The board may decide a longer period. Now here again you will find the Act does not speak anything so far as the timeline is concerned. So you will find at least for a minimum period of 3 years or such higher period you will find as the board may decide, you have to maintain. Now what will happen in case if there is an alternate director as an original director has appointed an alternate director? In that case, the alternate director can vote. The original director does not have a right to vote. The alternate director will receive the notice of as well as the circular resolution. Similarly, original director will also receive, but he will receive only so far as the information is concerned, and he does not have a right to vote. Next. Resolution not permitted. In 5 to 10 minutes, I will conclude, Kalidas sir. Resolution not permitted to be passed by circulation. Considering, so there are certain items, purchase and sale of material, tangible, intangible, not in the ordinary course of business, approve payment to directors, sale of subsidiary, 173 section, approving annual operating plans, budgets, capital budgets. So in other words, these are the various items where certain deliberation, discussions are required for arriving at a proper conclusion and decision. For that particular purposes, these agenda items need to be passed only at a board meeting or through VC mode, where you will find audio video or a VC mode where further deliberation can take place. Next. Section 175 of the Companies Act, passing of resolution. Resolution has to be circulated in draft. Necessary papers has to be given to all the directors. So it is original director as well as to the alternate directors. I think all these I have captured in the circular resolution, the SS-1, what I have just now discussed. The only thing is, if not less than 1/3 of the directors require a meeting, circular resolution cannot be passed. Again, the same we have already discussed. So it has to be placed before the board. Next. Resolution not to be permitted to make calls on shareholders. That is 173, what I have already stated. So as well as under 179(3). So all those provisions you will find it has to be done at the board meeting. Next. Minutes. Maintenance of minutes. Minutes happens to be a conclusive evidence which can be placed before the court. Even evidence as defined under the Indian Evidence Act of 1972, very specifically it talks about admissible evidence as well as inadmissible evidence. And in the admissible evidence, the minutes also, in various judgments it has come that minutes also is an evidence so far as the proceedings which has taken place before the board as well as before the general meeting of the company. So a maintenance of the minutes. So first, a distinct minute book for meeting of board and each of the committees. So in other words, there has to be a separate minutes book so far as the board as well as the committee is concerned. It may be in physical or it can be maintained in an electronic form. Many of the companies, you will find that they give a tab and they provide the various user ID as well as password to ensure that everything is in electronic form and nothing is there so far as the physical document is concerned. In those particular cases, we need to ensure that proper timestamp is there so far as the minutes are concerned. So company may maintain minutes in physical. So physical, it can also be maintained in the loose leaf, which shall be bounded periodically, maybe an year, maybe 2, depending upon the size of the minutes. It should be done. The pages of the minutes book should be consecutively numbered. When you go search through the ROC's portal as well as the various, as well as in the Google, you will find nowadays various orders have come on the paging of the minutes. And many the adjudication orders you will find where the minutes are not consecutively numbered, you will find many penalties have been imposed on all those companies. No pasting or attaching or tampering to the minutes are concerned. The minutes book, if maintained in loose leaf, shall be bound properly. Next, minutes book shall be kept at the registered office of the company, minutes book or such other place as may be approved by the board. So we need to specify where the minutes will be maintained in case if it is other than the course. Ruckus Wireless Private Limited, violation in preparation of the board minutes as well as not paging, company penalty 3,25,000 and officer in default 65,000. Next. There are plenty of adjudication order. I have only captured 1 or 2. Signing and others of minutes. Minutes of the meeting shall be signed by the chairman of the meeting or chairman of the next meeting. Every page to be initialed and final page to be signed. It need not necessarily only be signed, but now you also have to ensure date as well as place of signing that date as well as place or by the chairman signing that particular minutes. Scanned signature is not permitted, only digital signature if minutes are in electronic form. Directors can inspect the minutes of the held before his director. Sometimes you will find directors of the company cease to be a director. So the question comes whether he can inspect the board minutes. Yes, he has got the right to inspect the board minutes, though presently he would have ceased to be a director of the company. Similarly, whether the auditors, whether it is PCS, secretarial auditors, cost auditors, internal auditors, whether he has a right Yes, he has got a right to inspect the minutes of the meeting. A member of the company is not entitled to inspect the minutes of the meeting of the board unless stated in the articles of association of the company. Similarly, in case of a government companies, question comes whether any stakeholder has got a right to inspect the minutes of the government companies. So here again, you will find that you have to go through the Right to Information Act. Under the Right to Information Act, whether the information which is mentioned, captured in the minutes of the board meeting, is it confidential or is it going to create any law and order issue situation, or it is going to disturb the peace. There are many things which are prescribed. So in that cases, because articles of association may provide or not, in case the board does not want to provide, the Right to Information Act can be invoked, by virtue of which there are certain exceptions, by virtue of which these minutes, so far as the government companies are concerned, need not be shared or need not be inspected so far as these companies are concerned. Next. Section 118 of the Companies Act with regards to minutes. Minutes of the proceedings of each meeting shall be entered in the book maintained for the purpose, and along with the date of such entry within 30 days of the conclusion of the meeting. So the question arises, 2-3 question arises so far as these minutes are concerned. A, when does the draft needs to be circulated? You need to circulate the draft within 15 days from the date of the meeting. Within 15 days after the sending of the 15 days, 7 days time will be given so far as the comments to be received from all the directors of the company, and then within 30 days it is to be entered in the books. It is to be entered. It is not signature of the chairman, it is entry. In other words, the entry in the register is important so far as the minutes is concerned, and not the signature. The signature can take place at a later situation, or even it can happen at the subsequent board meeting is concerned. Second, the draft minutes question may arise. A draft minutes have been sent, and the directors of the company, or certain directors of the company, or few directors of the company, have not put in their what we say as their remarks or their observations, or they are not abstained, or they have not dissented to certain transaction. In that case, in case if they have orally mentioned in the meeting, then that needs to be captured in the minutes of the meeting. Sometimes it may so happen that there may be an afterthought which may take place after the circulation of the meeting. The one or the other director may feel that he should have either abstained, or he should have put certain remark, or he should have put certain observation, or he is dissenting to such resolution. In that particular case, it cannot be recorded in the same minutes, because the minutes is the record of the proceedings which has taken place in that particular meeting. So therefore, in case if that director wants to raise this issue, he can raise only at a subsequent meeting, where in the subsequent minutes the same may be captured. In other words, there may not be any correction in the said in the present minutes so far as the company is concerned. Third question which may arise is that the director has dissented, but it has not been recorded by the chairman. In that case, that can be altered by the chairman in the subsequent meeting. He can alter by and can be recorded in the said meeting. But the chairman decision is final so far as the recording of the meeting is concerned. Meeting shall not be pasted or attached to the minutes book or tampered with any manner. If the meeting is adjourned, the minutes shall be entered in respect of the original meeting as well as the adjourned meeting. So he needs to prepare both the original meeting minutes as well as the adjourned meeting. It may so happen that in the original meeting, a particular director may not be present. However, the minutes needs to be circulated to all the directors of the company, irrespective whether he has attended or he has not attended the meeting. Next. Okay, so again, you will find violation in stating the serial number of the minutes of the board meeting, violation at the, again, under the Companies Act 2013, we need to also read with secretarial standard. We also need to mention not only the commencement of the meeting, but also the conclusion of the meeting. Earlier days, under the Companies Act of 1956, we only used to mention the commencement. However, here in this Companies Act of 2013, read with secretarial standard, we should also mention the conclusion, the time at which the meeting has been concluded. So you will find in this particular case, the company was default of this, and you will find the company penalty of 50,000 and officer in default 10,000. Next. Preservation of minutes. So preservation of minutes, you will find minutes are the permanent record of the company. It shall be preserved permanently in the physical or in the electronic form with the timestamp. Office copies, so far as notes, agenda items are concerned, or any other items are, or any other related papers are concerned concerning those minutes, concerning a meeting, you will find they can remain for a period of 8 years, and or such timeline which is approved by the board of directors, whichever is later. The minutes book shall be in the custody of the company secretary. Next. The last item, I think this we have already discussed. Next. The last item is with regard to the disclosure. The disclosure is with regards to the report of the board of directors, which shall include a statement of compliance of applicable secretarial standards. Section 135(5)(f) of the Companies Act disclosure very clearly talks about that the directors have devised proper system to ensure compliance with the provision of applicable secretarial standards, and that such systems are adequate and operating. Similarly, under 205 subsection 1 and other provisions also, you will find that we need to make, even under the secretarial audit report, when we are issuing as a practicing company secretary, we are talking about the compliances of all applicable law, including the secretarial standards. Next. So with this, I would, there are again violation of secretarial standard, where comments of the secretarial standard was there, which has not been recorded. Observation was there. The management has failed to give the explanation. Violation of the para 9. Next. So with this, I come to end of the SS-1, which included the revised SS-1, because I thought it better, because the revised SS-1 which was approved, you will find only minor changes had taken place. So we thought it fit that we will go and we will talk about the entire SS-1, covering, including the revised changes which have taken place. With this, I would like to thank the Institute. I would like to thank each and everyone. Especially, I also wish to thank Vaishnavi as well as Manali Jain, who had helped in making this presentation. In fact, they had made the presentation compared to my contribution. I would like to thank them. I would like to thank the Institute. Over to you, Kalidas sir.
Thank you. Thank you. Good afternoon. That was a very elaborate presentation by Rao Saab, and I think he has covered every facet of Secretarial Standard 1. Now, as opposed to what I will try to do in my presentation, can we have my presentation, please? Hello? Am I audible? Can you have my presentation on the screen?
Yeah, you are audible, sir.
Okay. Can we have the presentation on the screen, please?
Yes, sir. Sharing, sir.
Yeah, share, please. Yeah. Are you getting it?
Yes, sir.
Yeah. Good afternoon, everyone. At the outset, let me thank the ICSI for giving me an opportunity to share my perspectives on Secretarial Standards 2. Mr. Rao has made my task pretty simple in that he has made a elaborate presentation on Secretarial Standard. One, of course, there are quite a few similarities where it comes to principles between SS-1 and SS-2, and therefore I shall not, harp upon the commonalities in terms of principles. And I shall, in fact, what I will do is that instead of rattling off the Secretarial Standard 2 as it were, because most of all of us in the fraternity are expected to be aware of the Secretarial Standards. What I shall do is that, as opposed to going on the beaten track, I shall capture I shall introspect on the standards and go beyond the written line and share some perspectives where it comes to the standards, even from this, from the repository of judgments which are available in the statute. So let's have the presentation, please. As Mr. Rao said, we have several standards, but only two standards have the patronage of law, as it were, Secretarial Standard 1 and Secretarial Standard 2. The other standards are recommendatory in application. That does not mean that we have to disrespect the other standards, given the fact that every standard has, in a way, endeavored to capture the quintessence of corporate governance, and therefore, as corporate professionals, we need to respect all standards, regardless of whether these have mandatory sanction. But where it comes to Secretarial Standard 2, the first version, which got the blessing under the law, was the version which was made effective from 1st of July of 2015. And subsequent to that, we had a revised version effective from 1st of October 2017 to capture the nuances of the changes that had happened in the law in the interim. And basically, the standard captures the principles that govern the conduct and convening of general meetings. And general meetings, as we understand, are those concerning the shareholders and other stakeholders other than the board. And the standard 2 is applicable to general meetings of the members, as also for class meetings of the debenture holders and creditors, etc. In fact, it also applies to meetings that are convened by the court. But only thing is that where it comes to the directions of the court, if there are certain specific directions which have been given by the court, which are in supersession of the standard, then the directions of the court shall prevail over the standard. But where it comes to the conduct, pretty much you shall comply with the procedure that has been laid down in the standard. Next, please. In terms of applicability, the standard does not apply to, can you go back to the earlier slide? It does not apply to meetings that are held under the insolvency code. So if you have a meeting of the creditors or under the insolvency code, you cannot have the applicability of the standard where it comes to such meetings. It applies to every category of company except for the one-person companies. Simple reason being that one-person companies have only one shareholder, and therefore there is no need to go through the elaborate rigmarole associated with general meetings. It applies, in fact, the present version of the standard makes the applicability of the standard to Section 8 companies also is the non-applicability is restricted only to the extent that while the standard per se will not apply, but the compliance with the other requirements under the law with regard to holding of general meetings shall apply for a Section 8 company also. And where it comes to private and general government companies, these are exempt under the specific notification of June 2015, but the notification will prevail, subject, however, to the caveat that the exemption as per the notification shall apply only in case where the private company and the government company has captured and filed the annual return and financial statements. Mind you, the present version of the standard does not talk about any tolerance level. So I assume that if the company, the private company or the government company has failed to file the annual return and the financial statement for one financial year, the exemption from the standard shall not apply to such a company. It does not operate the same way as the case of Section 164, where it comes to disqualification of directors, where there is a disqualification emerging only if there has been a non-compliance for a period of 3 years in a row. So here, there is no tolerance limit which has been specified. So the surmise would be that you will have to always apply the stricter procedure, and the surmise would therefore be that if you have failed to file the annual return and the financial statement for 1 year, the exemption shall not be available. Next. It also applies to companies which are set up under special enactments such as the Banking Companies Act and the electricity companies. However, in case there are any specific procedures that have been laid down under these acts, those procedures will apply in case there is inconsistency in terms of procedure with Secretarial Standard 2. And as Mr. Rao said, Secretarial Standard is only supposed to be a supplement. It is not a substitute for the law, and therefore it is supposed to be in conformity with the Act. And in the event that there is inconsistency between the Act and the standard, the Act will indeed prevail. Or alternatively, if there is a subsequent change in the law, in that case, the amended provisions in the law shall prevail as opposed to the applicability of the standard. Next. Well, I will come back to this slide, but in the meantime, let's understand what are we go to the next slide, please, and we'll come back to this slide. Yeah, we need to understand what is new in the version of SS-2, which is supposed to be applicable from April 1, 2024. I must confess that the changes are only cosmetic and basic, in the sense that firstly, there is a, the standard talks about para instead of paragraph. Now, para is actually a colloquialism, and now by way of language improvement, it is the expression para is substituted by paragraph. And as I said, there is an exemption to Section 8 companies and private companies. Private companies will, of course, enjoy and government companies will enjoy the exemption for the notification of June 2015, subject to their filing their annual return and the financial statement. Next slide, please. Now, what is new again? Now, you see, where it comes to ordinary business, items of ordinary business as laid down under Section 102(1), we are aware that in case of certain categories of companies, the appointment of auditors is guided by Section 139(2), wherein you appoint auditors for a period of 5 consecutive years. Now, there was a requirement under 139(1) under proviso to say that even if you have appointed auditors for a period of 5 years, you are supposed to seek the ratification of the shareholders where it comes to their appointment every year. Now, this requirement actually has been deleted consequent upon the deletion of the proviso under 139(1), and 139(1) proviso does not exist, so there is no need to now seek ratification. So therefore, you don't have to put as an item of ordinary business an item regarding seeking ratification of the members for the appointment of the auditors. Only thing is that you will have to confirm in the board's report that whether the auditors have confirmed that they are eligible for the appointment and whether they have not in any manner disqualified from acting as auditors. And secondly, the other change which has happened in the version is that, you see, para 16(1) has been amended to now recognize the requirement of e-voting to give effect to the amendment made under section 110. In fact, e-voting is a requirement for all companies which have unlisted companies which have got a shareholder base of 5,000 or more, and for, of course, every listed company. So, and the final change, as I could make out from the version for SS-2, is that, you know, the Act talks about companies which are registered under Section 8. Now, there is no license which is granted to a company which has been incorporated under Section 8. The earlier version of SS-2 talked about licensed companies under Section 8. Now, by way of a cosmetic change, the expression licensed has been withdrawn to be substituted by a company which is registered under Section 8. Now, can you go back to 2 slides earlier, please? Yeah, yes. Authority to convene the meeting. Now, Mr. Rao has spoken elaborately about who has the authority to convene a meeting. Where it comes to a general meeting as also a meeting of the board, there has to be an authority. The meeting has to be convened by a person who has been duly authorized by the board. Para 1.1 makes it clear. So if the company secretary is there, if he is authorized by the board, or if there is a director who has been authorized by the board, then the meeting has to be issued under board authority. And in the absence of if the notice is issued by somebody who is not authorized, in that case, the meeting is invalid. And there is a case law which I have given the citation 88 Com Case 245. And the board, it is the responsibility of the board to approve the notice or to authorize notice changes in the notice in the draft which is provided by the company secretary or the director. And it is only after the board has approved the draft or the changes in the draft that the notice is final and is fit for issue. There is no prescribed form of notice under the law. I mean, you don't have to say that. You can say notice is hereby given, : and then you say nature of the meeting, annual general meeting, date of the meeting, day of the meeting, time of the meeting. You can say it separately, or you can say notice is hereby given that the 15th annual general meeting of the members of the company shall be held on Tuesday, 15th of April, 2024 at so-and-so at the registered office of the company, etc., etc. So it can be in a continuous form as long as the quintessence of the requirements of a notice are captured, in the sense that you have to specify the date, you have to specify the time, you have to specify the venue, and indeed you have to specify the notice, the contents in the notice, because in a general meeting you cannot transact any business other than what is mentioned in the notice. And the notice cannot be conditional. You know, what is a conditional notice? You cannot say notice will be notice is hereby given that the annual general meeting will be held on such and such date, subject to the audited account being available. You cannot qualify, or you can't say that the notice is hereby given that the meeting will be held subject to the presence of the chairman. You cannot have any notice which is conditional or qualified. And there is a case law in England which is quoted in 2CH15, 1905. Next, please. Skip this, please. Skip this also. Yeah, periodicity with regard to the general meetings. Now, you see, every matter which concerns a meeting, general meeting or a board meeting, the reference is to a calendar year. Now, unfortunately, there has been a change in the schedule 4, where it comes to independent directors. Independent directors, originally, it was, in fact, the meeting of the independent directors once in a year is a legal requirement which is mandated under the Schedule 4. Now, the independent directors meeting was also originally supposed to be held in a calendar year. Now, the expression calendar year, for some inexplicable reason, was amended was replaced by the financial year in 2017, and the same was also followed in the LODR provisions, where calendar year has been substituted by the financial year. But I reckon that in as much as Section 96 and other provisions relating to general meetings and 173 talks about a year, and year is not defined. Only the Act defines a financial year. Year, therefore, refers to the calendar year, and calendar year has been defined under the General Clauses Act as to refer to the calendar year as per the Gregorian calendar, which refers to a period of 12 lunar months. And what is annual is something which is reckoned with reference to a year, and that is a decision of the Supreme Court in National Insurance. So you have to consider all provisions in the Act which relate to meetings of the board, relate to meetings of the shareholders and committees are to be considered with reference to the calendar year and not the financial year. What happens if there is a meeting of the annual general meeting is adjourned? Does it tantamount to a second annual general meeting? Of course not. Because in an adjourned meeting, you can only consider those items which have not been transacted in the original meeting, and therefore the adjourned meeting is only a continuation of the first meeting, and merely because you have adjourned it, it does not tantamount to your holding a second annual general meeting. Now, with regard to, there is a question which has been asked in the chat box. With regard to extraordinary general meetings, is there any limit on the number of the extraordinary general meetings that you can hold in a year? There is absolutely no limit. You shall hold general meetings as and when necessary. But having said that, it is to the discredit of the company secretary if he continues to have extraordinary general meetings, because he is supposed to envision, he is supposed to have foresight and capture everything that can be accommodated within the notice of an annual general meeting. And every general meeting, and there is no need to number the serial number of the extraordinary general meeting, because an extraordinary general meeting is an event-based meeting, and every general meeting other than the annual general meeting is an extraordinary meeting. Next. Now, this question, of course, may not be relevant today, but it was very relevant during the time of COVID. In fact, I had to face the problem personally when the government of India clamped down a national lockdown on 20th of March of 2020, if I recall correctly. Now, we in ACC, we had at that point in time, our accounts were closed on 31st of December, and therefore the notice for the annual general meeting to be held in 2020 was issued to be held on 7th of April. Now, there was no way the company could hold, and there is today only you have this norm of general meeting being held through audio visual means, but at that point in time it was all physical, and the question arose, how could we hold the meeting on 7th of April when the government had clamped down on movement of people across the country because of COVID? And we looked for some support because this was an event which was never comprehended. It was actually application of the doctrine of supervening impossibility, and we found that there was a decision in England in Smith versus Paringham Mines, where the court had held that if a notice for a general meeting has been issued, you cannot either postpone or cancel the meeting unless that postponement or cancellation is authorized by the company's articles. And very few companies in India have a provision for postponement or cancellation of a general meeting after the notice has been issued. But so we were in a predicament as to whether we would be violating the law if we held the meeting on 7th of April. But actually we would be violating the law if we held the meeting, because there was a clampdown on movement of people, and the secretarial standard also does not allow the cancellation or postponement. Paragraph 1.2.11 says that once a meeting has been convened, you cannot cancel or postpone. Of course, the guidance note contemplates postponement under exceptional situations such as the imposition of a curfew, riot, and so on and so forth. Now, where it came to COVID, the advantage we could make out a case was that there is a principle in law which talks about situations where if anything is impossible to perform, then you cannot invoke the law. Now, here was a situation where the impossibility of the circumstances were such that you could not hold the annual general meeting. And therefore, the theory with regard to impossibility of performance could be applied with success in the case of COVID, and we eventually postponed the meeting. Now, because the law, as I said, cannot compel the doing of the impossible act. And let me tell you, where it comes to the application of the decision in Smith versus Paringa Mines, the Supreme Court had concurred with the English decision in Chandrakant Khaire versus Shantaram Kale, and said that unless you have mandate by the articles, you cannot postpone the meeting. But however, the Kerala High Court has given a very pragmatic view on this in John Chandy, where they have said that if the board has the authority to convene a meeting, equally it has the authority to postpone a meeting under exceptional circumstances. So therefore, we can pause on this point and say that a general meeting can be postponed or cancelled if the circumstances are such that there is a justification warranting such postponement or cancellation. And you can take a view based on the decision in John Chandy versus Syrian Catholic Bank. Next, please. Now, when is the AGM held to be conducted? The AGM has to be held within 6 months from the close of the financial year, and the gap between two AGMs cannot exceed 15 calendar months. And where it comes to the first annual general meeting, the law is very clear. The law does not, unlike the 1956 Act, the law does not provide for the calling of the first annual general meeting until there is a close of the financial year. So the first annual general meeting has to be held within 9 months from the close of the financial year, first financial year, and there is no need to hold an AGM in the year of incorporation unless the financial year has also closed during the year of incorporation. And where it comes to the listed companies, there is a dichotomy in the law as between the law and the listing regulations. The top 100 companies are supposed to hold their annual meeting within 5 months from the close of the financial year, and of course also to provide a one-way webcast of the AGM proceedings. Now, of course, this is only theoretical because till September you can have general meetings on the audio-visual mode. Now, what will happen after 30th of September is a matter of conjecture. I reckon that the corporate sector has got quite used to this situation of holding meetings through audio-visual means. It also has equally the advantage of avoiding physical presence of certain shareholders who can be unnecessarily nasty. But we do not know what is the last word going to be on this. I reckon that there could be a hybrid process where you could have physical presence as also presence of people through virtual means. But I don't know, we'll have to work out the modalities, and perhaps the secretarial standard will also have to be fine-tuned with regard to the revised requirements of the procedure that will be emerging on us after 1st of October of 2024. Next. As I said, there is no form of notice. The notice has to be in writing. The law recognizes issue of notice in electronic means. So you could send notices to, as is being done now, through email. and it should state the date and day of the meeting, the date, of course, and the day of the meeting. The day of the meeting meaning the day in the week. And the time for commencement, the annual general meeting has to commence as per the explanation in the section 96 during business hours. And business hours has been defined to mean a period of 9 a.m. to 6 p.m. So as long as you start your AGM at 5:59 p.m., it is all right. There is no such thing which says that the AGM cannot continue beyond business hours, but you cannot convene the AGM beyond the business hours. Your AGM has to commence within the business hours as laid down the explanation under section 96. Now, where it comes to, then the question arises, can you hold an extraordinary general meeting beyond business hours? The law is silent. The law does not say whether the extraordinary general meeting has to be held within business hours. But many times it is necessary for you to read down on the law and construe it harmoniously. And an extraordinary general meeting, or for that matter, an annual general meeting, is a meeting of the members, and it is intended that members will participate. So therefore, you should not make it difficult for the members to attend an extraordinary general meeting by holding it beyond business hours. So I would advocate that the extraordinary general meeting also, of course, this has not been tested in the judiciary yet, but I reckon if and when it is tested, the answer will be that the extraordinary general meeting should also be held during business hours. And where it comes to the serial number, it is only necessary to state the serial number of the meeting in the notice for the AGM, and you need not do so where it comes to an extraordinary meeting. Next. The AGM today can be held, as Mr. Rao said, also on public holidays. That includes Sundays, a public holiday. Sunday is a public holiday under the NI Act. It cannot, however, be held on a national holiday. There are 3 national holidays. Now, what happens if the date on which the meeting is being held is declared subsequent to the notice as a national holiday? Then, notwithstanding that the subsequent notification says it's a national holiday, given the fact that when you issued the notice, it was not a declared holiday, you will continue with the holding of the meeting, right? And of course, to facilitate participation of the shareholders, you are supposed to provide a route map for the venue of the meeting, and the route map will indicate a prominent landmark which is closer to the venue. However, this requirement of a route map is not necessary in the case of a wholly owned subsidiary or a company where only directors and their relatives are members. Okay. The question that has to be answered is, can you change the venue of a meeting after the issue of the notice? Well, it could be that there is a supervening impossibility by which the hall where you were supposed to hold the meeting has been destroyed by fire before you held the meeting. Now, in such cases, you can opt for a smaller venue or a different venue as long as you inform the shareholders about the change in the venue, and there is a decision to support the view in Sikkim Bank Limited versus Chowdhury. Next. Contents of the notice. The items of the notice have to be split into 2 parts. One is items of ordinary business as laid down under section 102(2), and all items which are not part of 102(2) will be considered as items of special business. What are the items of ordinary business? Items of ordinary business is the adoption of accounts. Here we are talking about accounts as in consolidated accounts in the case of a holding company. Now, approval of dividend. Now, mind you, the Act defines dividend inclusively to mean dividend includes interim dividend. So therefore, the question arises whether you need to ratify the interim dividend that has been declared by the board. Now, one school of thought is that inasmuch as section 123 gives to the board the right to declare an interim dividend, there is no need to seek ratification. But again, the conservative view would be that inasmuch as the Act talks about the declaration of any dividend, So it would be appropriate, as is being done by a lot of traditional companies like TCS, etc. They always seek gratification of interim dividend. And today, of course, there's a SEBI have clarified that even if you are declaring dividend for your holding company, it is not a related party transaction. So there is no danger that the resolution regarding the approval of dividend, interim dividend, will be lost, because even everybody, including the related party, can vote on that. So it's a matter of interpretation as to whether you will consider interim dividend worthy of approval in the annual general meeting. Directors reappointment upon rotation. Now, when a director is retiring by rotation, of course, it's an item of ordinary business. But where it comes to the LODR provision, if you are seeking to appoint a director who is more than 75 years of age, and you are seeking to appoint him by rotation, in that case, that calls for a special resolution. So that would not be actually, in the case of a listed company, an item of ordinary business. And appointment of auditors, of course, is a item of ordinary business. And as I discussed, you don't have to consider the ratification as an item of ordinary business any longer, because of the withdrawal of the proviso under 139(1). All other items of business which are to be transacted in the annual general meeting, or for that matter, every item which is transacted in an extraordinary general meeting, is an item of special business. And the text of the resolution has to be provided in the notice for the meeting only, only for items of special business, not for items of ordinary business. And where it comes to an item of special business, you have to support the resolution, by providing an explanatory statement. Ironically, the present act talks about a statement. 173(2) in the 56 Act talked about an explanatory statement, but that does not mean that the present act wants you to be very cryptic where it comes to providing an explanation as to the reasons or the rationale associated with the special item which is supposed to be transacted as per the notice. And you will state in the explanatory statement only material information which is known to you as on the date of the notice. If there is information which becomes material subsequent to the issue of the notice, there is no mandate for you to disclose it. However, you might want to do it if the meeting is held physically on the floor of the meeting, if there is some material development which has happened subsequent to the issue of the notice. Next. The law talks about 21 clear days. 21 clear days means that the date of the meeting and the date of the notice are to be excluded. So that means there is 23 days. And if you are sending notice by post for the purposes of transmission, you are supposed to consider 2 days. So effectively, if you are issuing a notice for a general meeting, you are looking at a window of 25 days. Now, the question is whether this requirement of clear days, is this a mandatory provision or a directory provision in the Act? Because you see, if it's a mandatory provision, in that case, it has to be complied, regardless of the difficulty associated. But in 101(1), the expression used is may. However, you see, the use of may in a statute leads to a presumption that it is actually recommendatory. It is discretionary. The provision is discretionary. But I must warn you that that is not the rule always. Even the Supreme Court has held that even where the expression may has been used in a statute, if the non-compliance with the requirement is going to lead to an abuse of the law, then even the use of the word may shall be considered to have mandatory application. But where it comes to clear days, the Calcutta High Court has held that it is only a directory provision. Now, why it is a directory provision? Because what is so sacrosanct about 21 days? You see, the purpose is to enable the shareholders to assimilate the information that you have provided in the notice, so that they can take an objective view on whether they should vote on the resolution or not. And if there is the notice should be sent to all members, including preference shareholders, whether or not they have, the right to vote on every item. The notice shall be sent to the debenture trustees. The notice shall be sent to the statutory auditors. The notice shall be sent to the secretarial auditor. The notice shall be sent to every director, even if a director is present outside India. And suppose there is an accidental omission, in case there is, you have omitted to send, somebody has not updated the address, or you have not updated and you have missed to send, you have sent the notice to the original address, that is indicative of a bona fide. As long as the intention to not to send the notice is not by design, or the intention is not deliberate, in that case, it tantamounts to accidental omissions, and the meeting will not be invalidated by the fact that you have accidentally omitted to send the notice. Next. Quorum requirements are specified in the Act. 30 members are to be present personally in case where the company has more than 5,000 members. Now, what about those who are representing companies under Section 112 or 113? Now, if there is an authorized representative who has been authorized by the company, in as much as a company is only a person by a juristic person, the person who is authorized to attend the meeting on behalf of the company will be considered as being present personally. And the requirement of quorum is 15 members where the membership exceeds 1,000 members, and the requirement is 5 members where the number of members is less than 1,000. And the Act talks about the presence of the quorum only 103, if you look at it, it does not talk about the presence of the quorum for the entire duration of the meeting. So therefore, the conjunction is, or the interpretation is, that the requirement of the quorum is only necessary at the beginning of the meeting. Now that, I think, is not a correct way of looking at law, because a general meeting envisages participation of members, and therefore the secretarial standard, to my mind, is correct in saying that the availability of quorum should be ensured throughout the meeting, not necessarily at the beginning of the meeting. And you cannot transact in a general meeting any item other than the items which are stated in the notice, and that has been clarified in para 1.2.8. Next. The presence of the auditors. Now, the presence of the auditor is, including the secretarial auditor, is a requirement under Section 146. And if for some reason the auditor is not present, in that case, he should seek leave, and he should ensure that there is an authorized representative. If there is a secretarial, we are talking about a secretarial auditor, one of the partners of the firm should be present. And in fact, it is one of the duties of the auditors under 143.10. Admittedly, 143 applies to only statutory auditor. But if you look at 143.10, it clearly says that the provisions of this section shall apply mutatis mutandis to the secretarial auditor as also to the cost auditor. So therefore, the secretarial auditors, the statutory auditors, the cost auditors should be present in the general meeting. And the absence of the auditors is permitted only when the absence has been authorized by the board. Now, the presence of the chairman of the audit committee, NRC, and the stakeholders committee is required at every general meeting. 178.7 does not restrict its application to annual general meeting. So it talks about presence in general meetings, which includes an extraordinary meeting. So therefore, I reckon that the chairman of the audit committee, the NRC, and the stakeholder committee should be present at every general meeting. And you need to also report on the director's attendance in the AGM, and that has to be figuring in your corporate governance report. And the secretarial standard also talks, SS-2 talks about the chairman having to explain why a director is not present. So therefore, all the more that directors should ensure that they are present. Next. The chairman, in fact, Mr. Rao has explicitly mentioned about the importance of the chairman being present. Now, if there is a chairman of the board, he automatically, chairman of the company, he chairs the meeting of the general meeting. And if there is the chairman is not present, in that case, the members shall elect, ideally it should be one of the directors who should be appointed as chairman, or if one of the directors is unwilling to chair the meeting, the members amongst themselves will decide on. I remember one meeting of Bank of Rajasthan was presided over by a minority shareholder, because there was a strife in the bank and only a minority shareholder wanted to chair the proceedings. Now, if the chairman is interested in one particular item in the agenda of the general meeting, the right procedure is for him to stand down where it comes to that particular item, and he will request one of the his colleagues in the board, to preside over that particular item because of the conflict of interest. And once that item is transacted, then he will take over the chair again. Para 5.2 of the standard, to my mind, requires a review. Given the fact that today, for a listed company, you have the requirement of e-voting, remote e-voting at that, and the shareholders have actually completed the remote e-voting 1 day prior to the meeting, right? So therefore, where is the question of the chairman having to explain the objective or the implication of a resolution? Para 5.2 talks about before a resolution is moved, before the motion is moved, the chairman has to explain the objective and the implication of the resolution. To my mind, this is not actually practical, given the fact that e-voting is a requirement. And of course, where it comes to postal ballot, you explain whatever you can in the notice for the meeting and the explanatory statement. Okay. And e-voting is a necessity for listed companies as also for unlisted public companies which have a membership of 5,000 or more. And the facility of, notwithstanding that you have provided the facility of e-voting, remote e-voting at that, you shall allow the shareholders who are present at the meeting also to vote at the venue of the meeting. In fact, even in today's context where meetings are held through audio-visual means, at the end of the meeting, the chairman gives a 15-minute time within which the shareholders who have not voted through the e-voting process can cast their votes. Next. Appointment of the scrutinizer. I would point out that there is a small dichotomy in the standard where it comes to who has the authority to appoint a scrutinizer. Para 8.4 talks about the board having to appoint the scrutinizer, and indeed the scrutinizer has to be an independent scrutinizer. However, if you look at paragraph 9.4, it talks about appointment of the scrutinizer by the chairman. So I would say that it is the chairman who is authorized to appoint a scrutinizer, subject to authority being given to him by the board, or the board decides that the chairman will decide on the appointment of the scrutinizer, and accordingly the chairman invokes the authority. So I think at the time when we revise the standards, we probably need to look at this dichotomy between paragraph 8.4 and 9.4, where it comes to who has the authority to appoint a scrutinizer. And the voting process has to be absolutely transparent. And now how the scrutinizer is going to ensure that the voting process is transparent, where it comes to those shareholders who have voted through e-voting process, at the very most, he can examine the ballots and see whether there is any deletion, corrections, whether there is no authority or the number is not properly quoted. That is at the most he can ensure that there is a transparent process in the voting. And where it comes to the dissemination of the voting results through the e-voting, through the voting process, it has to happen now within 2 working days. So if you are holding a meeting on a Friday, given the fact that Saturday and Sunday are stock exchange holidays, you can issue the scrutinizer's report to a stock exchange latest by the end of working hours on Tuesday. And the voting results have to be displayed on the company's website as also in the registered and corporate office of the company, right? Next. Let us look at some general points which are, which are of importance. You see, where, paragraph 12 emphasizes on this point that you cannot make any modifications in respect of resolutions which are subject to e-voting, right? Now, because you see, the shareholders are in no position to voice their views on the resolution which has been proposed. So it is appropriate to provide that no modification shall be allowed in respect of resolutions which are subject to e-voting. Now, having said that, are we to assume that no modification at all will be allowed? If there is a mistake which is grammatical, typographical, etc., I think there is nothing wrong if you make an amendment which is which is of a typographical error, but you are not allowed to make modifications which change the context of the subject matter of the resolution. You are not allowed to. So therefore, again, where e-voting is not allowed, the standard clearly says modifications can be allowed in respect of typographical errors. But I reckon that you can take that latitude to consider even resolutions which are subject to e-voting process, as long as I said, the correction is only grammatical or typographical error is being rectified. Now, resolutions which are again proposed through the e-voting process in the notice cannot be withdrawn. This is very clear in paragraph 10, but I will give you one classic example. I will obviously, for obvious reasons, I shall not mention the name of the company, but a listed company, a large company at that, having issued the notice and having facilitated e-voting process, withdrew 2 items of the notice on the day of the AGM. Now, the matter never went to the court, so it has died a silent death. But it would be an appropriate subject for debate whether you could have withdrawn the notice after the issue of the notice, or withdrawn the resolution after issuing the resolution, and particularly after considering that shareholders had already voted electronically on the day prior to the meeting. Next. As I said, a general meeting once convened cannot be postponed or cancelled. And now, where it comes to the proceedings of the AGM and the general meeting, LODR says, Regulation 30 says, that the proceedings of the AGM and the other general meetings have to be reported promptly to the exchanges. Now, how do you manage to do that, given the fact that the results of the e-voting are your scrutinizers report may not be available on the date of the meeting? So to my mind, there is a two-way process associated with ensuring compliance with Regulation 30. One, on the date of the meeting, upon conclusion of the meeting, you can send an intimation to a stock exchange to say that the following items of business were transacted at the general meeting, without mentioning what was the result of the voting. And then you say in the note intimation that the result of the voting will be communicated to a stock exchange within the requirements prescribed under law. And then once the report of the scrutinizer is available, you send that to the stock exchange. So that way you can ensure compliance with. I don't think any stock exchange can say that you have not complied with Regulation 30 if you have not provided the results of the e-voting on the day of the meeting. Paragraph 14, of course, says that you cannot distribute gifts to your shareholders during general meetings. Now, what is a gift? The standard also talks about gift vouchers. Now, gift vouchers are slightly different from discount vouchers. So if there is a discount voucher of, let's say, 10% or 15% on the products of the company, I don't think that can be considered as a gift, because you have to pay for it. Admittedly, you have to pay a little less. So I am of the view that discount vouchers do not fall within the ambit of, but in any case, it is not correct from the standpoint of governance to to encourage gifting to your shareholders. So let us, as professionals, consider this paragraph very strictly. Next. No adjournment, as I said, is allowed unless the circumstances warrant. The chairman can alone have the authority to, adjourn a meeting with the consent of the members. He will do so only in the interest of the company. Please understand that if he thinks that his appointment resolution is going to be defeated because his friends are not present in the meeting, he can't take that liberty of adjourning the meeting for a selfish reason. The adjournment should be for reasons which are bona fide and which are done with the consent of the members. However, he can do so if the meeting is unruly or where there are genuine reasons associated with the adjournment. I recall one meeting of which I was a company secretary, and there was an agitation by a political party, and in spite of that, we managed to ensure that the meeting was not adjourned, and we managed to hold all the items and put it through the voting process. Right? Next. Minutes. You see, minutes of the Mr. Rao has already articulated on the importance of minutes from the Evidence Act. Minutes have evidentiary value as long as you can establish before the court of law that a meeting has been held. If you are not able to establish the meeting has been held, then if you produce the evidence by way of minutes, then the court may take it with a pinch of salt. Since you have not been able to establish that the meeting has been held. The minutes of a general meeting are slightly different from the minutes of a board meeting, but nonetheless, certain items are common. You have to mention who are the persons, directors who are present, whether the company secretary is present, the auditors are present. You'll have to record in the minutes that the statutory registers and the board's report, the auditor's report was made open for inspection, and the chairman of the respective committees are present. The minutes are supposed to be capturing the quintessence of what transpired in a meeting. See, minutes are supposed to only, therefore, contain a correct and fair summary of proceedings. If some shareholder has vehemently objected, you don't, deliberately eliminate that dissent in the minutes. You're supposed to capture it to the extent it is not derogatory, to the extent it is not defamatory, right? And as I said, minutes have evidentiary value in a court proceeding. And if minutes are not produced, the court can always presume that no meeting was held. And there is a case law to support it in 136 com case. Next, please. The minutes have to capture, although even in items of ordinary business, you don't have to mention the resolution on the body of the notice. While recording the approval, you'll have to capture the text of the resolution for the ordinary items of ordinary business also. And where it comes to the reporting, the results of the voting upon receipt of the scrutinizer, because the minutes are not going to mention the voting results unless the scrutinizer has made it available immediately on the table of the meeting, which is unrealistic. To my mind, the report of the scrutinizer will come late, and even that has to be, to my mind, minutized. Some companies attach the scrutinizer's report as an annexure to the minutes of the general meeting. In my view, it would be appropriate to capture it as a separate minutes and capture the announcement of the results by the chairman or the director authorized by the board in a separate minutes, and not make it an appendix to the minutes of the general meeting, because appendix is supposed to contain something which is transacted. So you cannot have an appendix of the scrutinizer's report as an appendix to the annual general meeting minutes. And the minutes have to be recorded within 30 days and signed. As Mr. Rao said, it's only important to capture, to bring it to reduce it to writing within 30 days from the date of the meeting. And you can, later on, it can be signed by the chairman of the meeting. Next. Now, adherence to standards as corporate professionals, like, doctors take a oath of Hippocrates. Now, as secretarial professionals, as corporate governance professionals, I think it is incumbent upon us to ensure that standards are strictly adhered to. Whether these are mandated or not, it is not material that it should have the stamp of authority of the law. The standard is intended to improve the qualitativeness of secretarial processes. And we as people who hold the torch of governance should ensure that we, many times I've been astounded by the fact that people say, why is it necessary to mention the serial number? Why is it necessary to mention the time of the meeting? Now, you can see Mr. Rao gave out several cases of adjudication. If you think that compliance is expensive, consider the cost of non-compliance. Please, for God's sake, consider that standards are, worthy of compliance. They have to be, even if it means that you walk the extra mile, you please do that and capture the quintessence of the standards in letter and spirit, not only in letter of the law, in spirit of the law. I have seen minutes of listed companies. If you have read 1 minute, you have read it all. I was horrified when I saw minutes of the meeting of the board for adoption of financial results. It says the quarterly results subject to limited review were placed on the table and discussed. Period. Then it says after discussion it was resolved. There is no attempt at capturing what was the discussion. Now, I think that is no way of reducing in spirit the quintessence of what transpired in a board meeting. And as secretarial professionals, we need to ensure that we respect secretarial standards, to my mind, are sacrosanct. And these are the last word and should be obeyed in spirit and in letter. Right? And standards are not to be belittled and are to be respected by the fraternity. And I assume that once the norm with regard to holding of general meetings is clear after 30th of September, we probably need to have a further revision, assuming, however, that the MCA is also proactive. In fact, somebody has mentioned in a question on Secretarial Standard 1 that, the standard still talks about the presence of persons in Secretarial Standard. Our standard talks about presence of directors in person in respect of items which are prohibited. Now, the reason why it has not been amended is that you can only amend if MCA has only chosen to allow amendments in the Secretarial Standard, which has been captured by the Companies Amendment Act of 2017. Now, Rule 4 in the directors' meeting rules was withdrawn in the year 2021, and Rule 4 having been withdrawn, now you can have any item of business transacted by the presence of directors through virtual means. So it does not mean that our standard is actually outdated. As Mr. Rao said, you can make changes only if the government allows you to make changes, right? So I assume that we haven't heard the last thing on the Secretarial Standard 2 until after 30th of September 2024, when we will know what is the procedure going to be. I think I have come to a conclusion. Next slide, please. Is there any? Yeah, I have come to the conclusion. Well, we have received a number of questions depending upon what the moderator has to say when it comes to availability of time. We can take the questions. Mr. Rao and myself can alternate and take the questions, or else we can close the session. Thank you very much. Well, there is a disadvantage in a web situation. You don't make eye-to-eye contact with the participants. So I assume that those who have keyed in have stayed for the duration of both the presentations. Thank you very much.
Thank you very much, sir.
Thank you, sir.
Thank you. Can we have some 10 minutes allotted for some questions?
Yes, I think we'll take a few questions.
Yeah.
Most of them have already been answered during the presentation, but still we will take a few of them.
Yeah.
Chandrakeshwar, shall I take or?
Yes,
the first question which has come is revised SS-1 and one para 1.2.3 in par not in consonance with company's meeting of board. As per the latest notification, there is no restriction on any matters to be dealt. I think I have also answered and you have also answered with regard to the rule 4, which has already been taken off, and by virtue of which physical presence in person is out and all the matters could be discussed in the video conferencing. Can you adopt the revised standards in financial year 23-24? Yes, you can adopt the revised secretarial revised one financial year, but it has to be in the first meeting because your notice, notice, agenda, and all has to be done as per revised only. Similarly, because your first meeting will be held in the month of either April or May, depending upon your accounts. Audited or unaudited accounts which you are going to circulate to all the board members. So therefore, notice and your agenda item has to go as per the revised standards only.
Yes, sir.
Correct.
What will be the difference between the previous secretarial standards and the revised secretarial standards? I think already you have already said about the cosmetical changes, what has been brought in by virtue of these particular changes. What will be the date of signing of the financials if the board meeting is held through video conference? So this question has come. Now, and not only this question, I think there may be also a question that adding to this question, that there may be directors also present throughout, not only in India, but throughout the world. So therefore, you will find there may be a time difference which is there, or one director may be traveling and he need to sign. The easiest way to overcome this would be to carry a digital signature, because the time would already been captured or the date would have already captured in those particular, I mean not time, by virtue of the digital signature being affixed. Because I have seen myself in one or two cases before the register of companies where auditors are signing on different dates, as well as the directors and CFO signing on the different dates. So by virtue of which, though they would have mentioned one in India, another in one in Bangalore, one in Germany, one in Australia, and blah blah blah, you will find the ROC coming out with show cause notices. To avoid that, the better option would be signing through the digital signature. Any other mode, Kalidas sir, if you could highlight?
Yeah, I agree. That is a correct way of ensuring that you don't get a notice. I quite agree.
Yeah. Then next is, in case of minutes to be signed by the chairman of the subsequent meeting, how the timeline of 30 days for approval of the board minutes can be complied with. Now here, nowhere the word approval is mentioned so far as the act is concerned. It is only the entry in the record or entry in the register, case the case may be. So therefore, as already indicated, 30 days is only with regard to the entry of the minutes, the final minutes which has been approved by the board, and signature can take place at a subsequent occasion or on the 30th day. Subsequently, in the next board meeting, the board only has to take a note of it. The board need not have to confirm it, because already it is a final minutes which has been signed. Any other view, Kalidas sir? Yours.
Yeah, I agree with you. In fact, I wanted to add that, the procedure of getting the minutes signed at the next meeting by the chairman is actually a matter of courtesy. Because you see, it should be signed when the chairman is signing. He should be signing it in front of all other directors. It's a matter of courtesy. Even if a meeting has not been held, as long as you rightly pointed out, it has been reduced to writing, and you have received the views of all the directors within 15 days from the date of the meeting, it is all right for the chairman to sign it even without the next meeting being held. But that is not normally done because it's a matter of convention and it's a matter of courtesy.
Yes. Whether a non-executive, I will ask, I think, a couple of questions you can take directly. Whether a non-executive director settled out of India is requested to attend any meeting physically.
No, there is no need. You see, the law allows virtual presence. The only thing is he must ensure that he is present at least virtually. Otherwise, he will have disqualification to 167 if he is not present for 12 months.
Yes, yes. The same answer I had. How to keep the notice of attendance when the meeting was conducted through VC? I think this I have already discussed in my presentation.
This is also mentioned in our standard. This is mentioned. Yes. It will be the secretary will authenticate in the standard. It has been mentioned. Yes. It has to be captured virtually.
Yes, it will be captured virtually as well as it will be mentioned in the minutes that he has attended to a video conferencing
and such place.
Yes. And also in the attendance register also it will be mentioned as attended through VC.
Correct.
How to keep note of attendance when meeting was conducted through VC, whether noting of attendance in minutes, I think that we have already discussed. When a resolution is proposed to pass by circulation, I think that is also discussed. What is the effective date of resolution? I think that is also discussed. Whether the minutes of
it's in the standard. Sir, it is in the standard. It is in the standard.
In the standard which has been already informed in this webinar. Whether minutes of board meeting are required to be circulated to directors who did not attend the meeting. Yes, minutes needs to be circulated.
Yes.
In physical board meeting, if one director is attending online, does it required to record the whole meeting electronically? In physical board meeting, if one attending online, does it require to record whole?
If he is attending online, you will have to record the entire proceedings. Even if one director is present through audio-visual means, and the rules also clearly say that the recordings are allowed to be preserved until the audit for the year is over.
Yeah. A retiring director can inspect the minutes of meeting after retirement. I think that we have already dealt. Yes, he can. If the chairman stays outside India and comes once or twice in a year to India, how to comply? Already it is if the stays outside India and comes again, timestamp also can be done there.
Yes.
If any changes in the previous meeting minutes are discussed in subsequent meeting, shall in the minutes, I think we have already discussed, but once again.
I can say this again, that you see the minutes of the previous meeting as approved cannot be tampered. If the dissent has been given after the conclusion of the meeting, the director who is making the dissent has to make a note in the next meeting so that can be recorded.
Yes. Whether secretarial standards are applicable to foreign subsidiary of an Indian listed company.
I don't think so, because I don't think our jurisdiction does not extend beyond India.
Yes. What are the provisions for rescinding, modifying, cancellation of arrear resolution by shareholders?
Can I answer this?
Yeah, please go ahead.
You see here, suppose the shareholders have given a sanction to proceed on particular matter, and if the board feels that it is not appropriate to proceed. Now, suppose you took an approval for sale of undertaking. The board decided to stay on in the business. The board can always decide to rescind and by resolution and add it in the next year's director's report and say this is the reason why we did not go ahead.
In fact, to add to that, I may say that in the subsequent, it can be an enabling provision. However, in case the board meeting can discuss about whether to do it or not and record the reasons for not doing it.
Correct. Agree.
How shorter can be a general meeting, shorter notice? Can date of notice and general meeting be on the same date?
It can happen in the case of a wholly owned subsidiary, that you hold the notice, issue the notice in the morning, you hold the meeting. But then, I think these are all shortcuts. I don't think we should allow these things to happen. We should not advocate as an institution.
Yes. Can chairman attend the AGM through video conferencing? Yes. There is no bar. Whether AGM is also required to be serially numbered. AGM, whether he talks about minutes or what is not known, it says AGM. Minutes has to be serially numbered.
No, EGM.
I'm sorry.
EGM
I'm sorry.
does not have to be serially numbered.
Yeah. Sorry, because I was talking on board, so got carried away. I think more or less the question has been answered.
Yes, sir.
One more last question I think we will take. A special resolution passed in the AGM can be modified or cancelled by seeking the approval of shareholder again by EGM. Postal band, what is the time frame for such modification of the cancellation?
Yes, it can be done. There cannot be any time frame. After all, these are all decisions, business decisions. If the board decides to relook at that proposal, then the board can always do so. Right?
Yes. Last question.
There's one question which I think we can answer. Preference shares, they are saying preference shareholders are having rights to voting rights. Preference shareholders have the voting rights if there is dividend in arrears for 2 years. Now, does that make them equity shareholders? It does not make them equity shareholders. It only makes them entitled to vote on all items. It does not mean that they have become equity shareholders. They have got the rights of equity shareholders, but they still remain preference shareholders.
Yes.
So I think we have answered all the questions.
Yes, since the presence of members through VC and not physically, proxy provisions are dispensed with. Is it allowed? There are many companies who call VC as well as meeting. I had held one. I am to say I have seen one meeting where EGM has been convened in a hybrid mode. So therefore, presently to say that proxy we should dispense may not be correct.
Correct. Agree.
I think we have taken most of the questions and few of the questions have already been answered earlier.
Thank you, sir. Thank you, sir, for addressing the queries as well as enlightening all the participants, members on the secretarial standards, as well as taking through the journey of secretarial standards while highlighting its importance in today's corporate practice. And on behalf of the Institute and on behalf of the participants present, I would like to express my sincere thanks to the speakers for their wonderful presentation. And thank you very much, sir. Thank you.
Thank you. Thank you very much.
Thank you, sir. Thank you. Thank you. Thank you, Chanakeshwar. Thank you,
Thank you, sir.
Thank you all.
Thank you.
By this, we conclude the session. Thank you.
Yes.
Bye-bye.
Thank you. Bye.